Good morning, Your Honor. May it please the court, Russ Hart, myself, and Edward Warner.
Could you raise the microphone slightly? It's a little, there you go.
Thank you, Your Honor.
Bingo.
Myself, Edward Warner, and the federal defenders of Montana represent the defendant, appellant Gabriel Metcalf in this case. Your Honor, when we step back in this case, big picture, the Gun-Free School Zones Act tells Gabriel Metcalf you can't have a firearm if you're within 1,000 feet of a school. It says you can have one if you're on private property. Mr. Metcalf lives within 1,000 feet of a school. He has this dispute with his neighbor, and he begins carrying a gun on his property. And we get 911 calls saying there's a gentleman near the school on his property with a firearm. The law also tells Mr. Metcalf there's an exception if he has a license issued from the state in which he resides, which the school is located. Montana passes a law that says if you do not have a violent felony and you're not prohibited under the Constitution, you have a license. Mr. Metcalf, looking at the law, really could not have had any reason to think he'd be prosecuted for what he did in this case. It was only the case, the law of this case that told him his license was invalid. When we look at the Tate decision, this is an issue where the federal government, the Congress, put this directly to the states to implement a licensing procedure to grant licenses. The Congress, at the time this was passed, had representatives from Montana in it. I think it was known to those people that a law like this was likely. And then
So let me jump in here because there's, reviewing this case, I've spent a lot of time in this case, I think we all have. There's a Supreme Court case from 2019, Rahafe, which had to do with whether someone who was in the United States on an expired visa could have a firearm. And the Supreme Court said that in that case, Rahafe had to know that he was ineligible to have a firearm before he could be prosecuted under the 922 offense. I'm wondering in this case if there isn't a similar problem for the government in that here's a case where the question of whether or not he's eligible to have the gun is a legal one because he had a license under Montana. He talked to local authorities. They said he could have it. And then a court, after the fact, determined that he could not. I was curious in the way this case was framed in the trial court, was this issue a Rahafe-type issue, like a knowledge, like he has to know he's in violation of the law? Did that ever come up at all? Was that ever briefed or argued?
never briefed or argued, Your Honor. It was considered. A motion was not filed. I view that as a trial issue, and we ended up settling this the morning before trial.
Right.
The mens rea element of this, it was not raised in the district court. It was not raised in this briefing. And really, when the district court issued its order, that is when that issue really arose in my mind and possibly should have been the subject of further briefing and given the district court and this court a narrower path to relief for Mr. Metcalf.
Now, under the plea agreement in this case, could that argument have been made? The one I just threw out there. Under the plea agreement in this case, is that within the narrow waiver?
Well, I guess the waiver carved out and it allowed Mr. Metcalf, and Your Honor, I didn't speak earlier. I'd asked to reserve 5 minutes of my time for rebuttal. Mr. Metcalf, he was allowed to appeal the denial of his motion to dismiss the indictment. That was not addressed in that motion, but I do think that, and if the court would like further briefing on this, I'd be happy to submit it. That issue did arise as a result, in my mind, of the judge's ruling, of Judge Waters' ruling on that licensure issue.
And keep going with your argument. It's just something that's troubled me about this case.
Yes, and I view this more as a licensure issue, mental state issue, than a Second Amendment case. I think that there are narrower grounds to decide this case on than the Second Amendment and Bruen. The licensing issue in this case, Your Honor, there is one case on point, U.S. v. Tate, out of the 11th Circuit. And I think the court's appetite in that case was not, it really did not want to step in and tell, I believe it was Alabama, that their licensing scheme was invalid. And when we look at that, the licensing statute in Alabama, it actually has a proper cause type element. It has I think you have to show good cause that you're in fear for your safety to get a license to carry a gun in the school zone in Alabama. This is pre-Bruen. I'm not sure that would that may be too restrictive now, given a little bit of time. But Mr. Metcalf, I think a very interesting thing about this case to me, Your Honor, is just how unrelated the school was to what was going on here. In Mr. Metcalf's mind, for sure, this is, I mean, it's a little bit silly, Your Honor. We have a 50-year-old man who has a 25-year-old neighbor that is picking on him. That is what got us here. And what he did was arm himself, which the Second Amendment, Bruen, the Supreme Court, has told him is his right. He armed himself with the only firearm he had. It wasn't one that he could conceal. It was something that was conspicuous when he carried it. Yes, Your Honor.
Yeah, I just procedurally, this is a conditional guilty plea.
Yes, Your Honor.
And so, what was the issue that you conditioned the guilty plea on? Precisely.
It was on the denial of Mr. Metcalf's motion to dismiss his indictment by the district court.
Okay, it was just the overall the appeal of that denial.
Yes, and that motion dealt with the license and with the Second Amendment arguments.
Okay.
So Mr. Metcalf, he's been assaulted by this gentleman. He has had serious things happen. They didn't happen on his property. That happened in the alley, as the pre-sentence investigation report in this case details. The way this law is being applied, Mr. Metcalf could not leave his private property, and the law says private property, not just his private property. Mr. Metcalf conceivably could have trespassed and not gotten onto the sidewalk in this case, and he wouldn't have violated the law. It was only when he stepped onto the sidewalk that the government argues that he violated the law. And that was a theory that was put forward for the first time, I would suggest, in this case. And when we look at the Wolford decision, found that the default rule being flipped did not violate the Second Amendment because those plaintiffs could still carry on public streets and sidewalks. In this case, the public street and sidewalk becomes the school zone when Mr. Metcalf steps onto it. And when we look at Heller, when we look at Bruen, Heller, the Supreme Court determined that an individual has a right to possess a firearm in their home unconnected to service in the militia for self-defense. At issue in that partially was a law that said firearms stored in the home need to be unloaded, rendered inoperable, stored in a case, what have you. Bruen comes along and says that right exists outside the home. What the government has argued is that Mr. Metcalf, A, could have gotten a license. I would submit that he did. It's the only license available to him to carry this weapon, and it was declared invalid. They also argue that this is more of a transitory storage requirement. When he leaves his property, all he needs to do is lock it up, and he can leave. The problem is, in Heller, the Supreme Court said that is an act of disarmament. That cannot happen inside the home. In Bruen, the Supreme Court said that right exists outside the home.
Is it correct to say that your license is invalid?
I suppose it wouldn't, Your Honor. I believe what Judge Waters held was that he had a valid Montana license. It was not sufficient to invoke the...
It didn't qualify to let him patrol up and down the street across from the school.
Yes, Your Honor.
Yeah.
I guess what I am saying is that the law in Montana directly on point for the Gun-Free School Zone Act was held not to afford him protection. I shouldn't have said it was invalid. Thank you. Your Honor, I see that I'm at my 5 minutes here. I'd like to reserve the remainder for rebuttal. Thank you.
Very well, counsel. I did have one question for you. Is Mr. Metcalf in custody right now?
Mr. Metcalf is not in custody. He received a sentence of probation in August of last year.
But there was that assault charge. Has that been dismissed? State law?
I believe it's been disposed of. I don't know the...
Okay, thank you.
Thank you.
May it please the court. Good morning. My name is Thomas Godfrey with the District of Montana for the United States. Looking at this case, I want to start by addressing what the court raised in terms of the mens rea requirement under REHAVE. There is a mens rea requirement in 922Q2A, and that is that he knows that he's in a school zone. Much like in how REHAVE has been held to 922G1, someone who's a felon, they have to know that they have the prior felony conviction. They don't have to know that them having a prior felony conviction is what makes them in violation of the law. They have to know about the requirement. So there was a mens rea requirement here, and to plead guilty, he had to admit he knew he was in a school zone. The issue in this case was that Mr. Metcalf did not believe that that law was constitutional. He told that to law enforcement. He'd been told he was in violation of federal law and was asked to stop, and he refused to stop and stated the law was unconstitutional. Looking at as applied to the facts in this case, Mr. Metcalf went beyond someone who was just on their own private property or transitorily going through a school zone. He was daily, repeatedly patrolling in the street, on a crosswalk directly across from the school that students used to go to the school, the sidewalks. He would stand in the street staring at the elementary school holding a firearm, staring into traffic and staring at the school. That's beyond these examples of someone who, is far away, can't see the school, just an innocent, homeowner trying to protect themselves with a firearm. And what we're looking at these cases, the Constitution is applied to these facts. And so I think it's important to note that Mr. Metcalf in these facts was physically in the street, in the crosswalk, patrolling repeatedly with a gun, and exhibiting other concerning behaviors such as, searching his property for landmines, just behaving in extreme paranoid ways.
Look, I wouldn't want this guy across from school either. I understand why the police intervened. I understand why law enforcement intervened. That being said, under Montana law, he is licensed to have that firearm.
Under Montana law...
Let's start there.
Sorry, Your Honor.
So I'm saying, let's start there, because I think we don't even get to the Second Amendment Bruen question unless you prevail on this question first. So let's start with that.
Sure, Your Honor. 922Q2B2 does have an exemption where a state can create an exemption where someone can get licensed to possess a firearm in a school zone and be exempt from the federal statute. Now, that exemption requires that before someone is licensed by the state, so before they're licensed, the law enforcement of the authorities of the state verify that the person is qualified under law to receive the license. So the Montana statute says everyone in Montana is licensed to carry a firearm pursuant to the Gun-Free School Zone Act, except for individuals who have prior violent felony offenses and individuals who are not qualified to possess a firearm under the Montana Constitution. But there is no prior law enforcement verification at all, which is a specific requirement under the federal statute. So Montana sets up essentially what would be a framework to license someone. Here are the people that we would not want licensed under Montana law to be in a school zone, but does not require the prior law enforcement verification, which is necessary. And that's very different from Tate, because in Tate in Alabama, the issue was whether the sheriff had to run a background check or some sort of, what the verification needed to be by prior law enforcement. But Tate you had to go to the sheriff to be licensed, and the sheriff had to determine you were qualified. So that tracks the federal statute.
You're interpreting verify here as sort of confirm after the fact. Is that because verify can mean that, but I think even in Judge Waters' decision, the dictionary definition, I believe it's Judge Waters' decision, had the word like assert. Like that's another type of verification would be to assert. You acknowledge that verification can mean confirming something out of the fact, but it can also mean verifying something can mean asserting that something is the case?
I wouldn't disagree with that, but I note that the federal statute requires before the licensure occurs.
So I don't think that. So I'm just trying to narrow down where your argument is. I'm not sure that much of your argument depends much on verify because of the fact that they call it ambiguity or the breadth of what verify. But you're really relying on the fact that it has to be before, so that the time, and you're relying on law enforcement. Those two things. Am I correct on that?
Well, I would also argue that Montana didn't verify under its own statute that he was in compliance because there was no check that he was a prior.
Well, no, but if it just means to assert that something is the case, and if you're asserting that, let's just use that you're not you don't have any anybody that doesn't have any nonviolent felonies has a license, then you'd be verifying that the state would be verifying that you have this license. They'd be asserting that you have the license if you use the word assert as a synonym.
I think it would be more interesting in that circumstance if it was no prior violent felonies in Montana, right? Because then Montana would have its own record, but it's no prior violent felonies. That
the problem is you're smuggling back in the idea of verifying as confirming. But I'm saying verifying can mean to just assert. Like I say, you are something, and I'm just asserting it, right? I'm not verifying it. I'm not confirming it in that sense, in the confirming sense of verifying, but I would be asserting it. The same way that a state would say, the same way that that a court could say you're a member of a bar. They're just asserting that but you could call that verifying within the.
Well, I think under the federal statute requires that. When you read actually what the federal statute has prior to the license being granted, law enforcement authorities verify, I think it very clearly just states that law enforcement authorities have to do something, right?
But you're insisting that whatever law enforcement authorities is, they have to do something, but that something could be asserting.
I think
it's kind of, in that sense, your argument's not that different than Alabama's. Alabama's like, they're not really doing anything. The sheriff's not doing anything. You're supposed to be doing a background check, and the sheriff is just basically asserting after the fact. That's kind of what their argument was.
No, I think it's very different because in terms of what the state has to do to verify someone, that's left up to the states. So Montana has, a category of people that aren't allowed to be licensed to possess a firearm in a school zone, the prior violent felons and under the Montana Constitution. I think it would be more interesting if Montana didn't have that category. If Montana had said that everyone in Montana is licensed to possess a firearm.
The way you're saying what you're just saying right now is that Montana has asserted, the legislature has asserted that certain categories of people are licensed and certain categories of people are not. But that seems to me to fall within the meaning of verify if you understand verifying as including the possibility of meaning assert. Is it? So I'm trying to figure out why you're saying that verify would not encompass that sort of.
Well, because I think they have to verify prior to them issuing the license, and Montana licenses, just everyone.
Verify prior.
To verify prior to the license. That's what the federal statute requires.
But so then that takes me back to what you're relying on. There's three different things you could be relying on. That this is not verifying, this is not before, the timeliness aspect. And the before thing, as an aside, obviously, if verify is within the words, then the legislature did this before this conduct because the legislature. So I don't know where before does very much for you. It seems to me that your strongest and best argument is law enforcement, that the legislature is not a law enforcement authority.
I disagree with that. My argument is that I think, as an example, if the legislature said, here's the categories of people who can't be licensed to drive, people with various prior convictions, for reckless driving or drugs or alcohol or the like, and said everyone is licensed to drive, but then also said before someone can get that license, we have to verify that they're qualified under law, because that's important too. The prior verification is they're qualified under law.
But you just used that last verification was to confirm. Verify that, but take that out of your mind for a second. Are you just disagreeing that verify cannot mean to assert something? Or do you agree that verify can mean to assert something?
I don't think verify as it's used here in the federal statute can just mean you can say everyone's licensed except these people and it meets the requirement.
So that is, so you're saying, okay, that's actually important. And if it did mean that, do you acknowledge that, so if verify does mean to assert, so you're saying maybe it can mean to assert, but in this context it doesn't mean to assert. That seems to be your argument.
I'll be honest with you, Your Honor. I'm not entirely sure what, I think we may be talking about two different things. I think that just reading the federal statute, In reading the Montana statute, which sets up a framework for who can be licensed but doesn't require prior law enforcement verification, there is no check in the Montana statute. There is no verification at all that someone is not
Well,
a
I
felon.
find it odd that you say that because, all the legislators that voted on that, like literally the law says, we passed this law to comply with the verification requirements. So obviously a bunch of people in Montana, the lawmakers in Montana, thought that verification could mean something other than the way that you're using verification. And I understand that you may be saying, well, they were just wrong about that. But it seems I'm trying to figure out, is your argument at a really high level that verification just can't mean assert, or is your argument at a more granular level, well, verification can, but here it doesn't mean to assert?
Well, federal law, it governs how we interpret federal statutes.
But there's no definition of verify. You acknowledge that, right? There's no definition in the statute of verify here.
There's not, but I think when you read the statute saying that prior to an individual obtaining a license, the law enforcement authorities have to do something, verify that they're qualified under law.
You could say prior to you getting to practice law in Montana or Nevada or pick your state, the bar has to verify that you are a member of, and that could mean two different things. It could mean that the bar would go through and confirm that you are a member of the bar, but it might also mean, as I understand it, that the bar could assert that you are, because that's what the bar does. It's the one who decides whether or not. And in both those meanings fall within the meaning of verify, is my understanding.
But I think if the bar had a category of things that would exclude you, such as I have prior convictions or prior ethical problems, and they're saying that that's verifying that prior verification requires the action. And in this case, it's even more removed from that because it would be, using your bar example, the bar has some sort of investigative authority.
Right, so if the bar had different categories and some of those excluded you, the bar would be verifying that you fell within in the sense of asserting. But if you could have both kinds of verification. After the fact, you could say, well, is he actually a member of the bar? Because we think he has a felony, and the bar could go and confirm, right? So it seems to me like part of the challenge that we're having here is that when I'm using the word I'm saying, well, it could mean both, and every example you're giving me of no, it can't, you're falling back on the confirmed type of verification. And so I'm just trying to figure out, your position must be, I assume, that verification cannot mean assert, and I'm not sure why, but I think it's either the context or it must be the context that you're saying that.
The statute requires that law enforcement authorities verify prior to a license being obtained. Montana law doesn't require that at all. It takes that element, that aspect of the exemption entirely out of it. That's the reason why the district court found that licensure doesn't comply with 922QB2 because there's just no law enforcement involvement whatever, and it has created categories that take people out of it. So absent that, and again, as I said, federal law determines interpretation of federal statute. Montana, essentially takes that provision out of it, but by that same token, they can't then license people under the 922Q2B2 exception.
So let me jump in here because let's say, and again, this is really splitting hairs, but this is a criminal case. So let's say I agree with your reading of the statute. Let's say I think your reading of the Montana statute is better than what Mr. Metcalf's reading. But this is a criminal case, and if it's really close, and we have certain axioms about constitutional avoidance, we have certain axioms about lenity, which we don't invoke very frequently, but why isn't this one of those cases where we have a situation where a guy, and look, like I said, that weird lawnmower thing he had with the gun, I don't like that. I don't like that being near a school. I don't like that one not near my house either. But the legislature of Montana has said he can have a gun. The police said he could have a gun. In a criminal case, isn't that a problem?
Well, I think this is a federal statute, so whether he was in violation of Montana law or not is irrelevant in this case.
Well, but it's not totally irrelevant. I'm sorry, go ahead, Judge Schroeder.
Well, if I understand your position, that the statute says that there has to be a verification before there is issuance of a license. And in Montana, I may not understand how this works, so help me. In Montana, they don't do anything before issuing a license. Is that correct?
They don't. There isn't a physical license or a licensure board or you don't go to law enforcement, there's nothing. They just say everyone's licensed except for these people. It's really a back end.
There's no piece of paper that says I'm licensed.
There is not at all. Montana just essentially tries to exempt Montana from that statute, but then also, which is problematic, creates categories where people can't be exempted from that statute. So really how this works in Montana is if you're found in, a school zone with a firearm, and then they then later determine that you have these violent prior felonies, you'd be in violation. So it's back end rather than prior, which is the issue. But talking about I completely understand constitutional avoidance and the importance of that, but I don't think the court can do that in this case without entirely writing out that section of the 922 exemption, which requires that prior law enforcement verifications. As the district court stated, Montana just can't on its own say its own statute is in compliance with federal law when it doesn't comport with the specific requirements of that federal law. And there's just no circumstance where what Montana did here with the licensure requirements meets that requirement of prior law enforcement verification. They essentially just exempt Montana from this entire statute.
And like I said, let's say I agree with you on that. But again, the inquiry, as I see the inquiry is there's like a civil review of the law, which you've just done, and let's say I think you're right about that. But then you have to move this to a criminal case. And the question is that the defendant have fair notice that this would actually, and that's what lenity's really about. It's about fair notice. So you got to jump over to that side. It's not really a clinical reading of the law like a law school exam. It's in the mind of this defendant. Why wouldn't we read the law in a way that would favor him in light of the kind of unusual circumstances in this case?
I'm out of time, Your Honor.
Please answer.
Well, I think the reason the court should apply the law, as I'm arguing, is that is what the federal law requires. And there's just no way to bend federal law to comport with Montana's licensure requirement being in it. Two, in terms of the mens rea requirement, he has to know he's in a school zone. That is the mens rea requirement. I'd note also that issue is not before this court. That issue wasn't raised at the lower court level, and he didn't reserve that. But in terms of that, there is a mens rea requirement here. And two, in terms of like the fairness and someone saying they're licensed, I mean, Mr. Metcalf never raised this with police, because Montana's exemption just exempts everyone. There's no license. He didn't go in, get anything like that. He never said he was licensed to police. He said the gun-free school zone statute is unconstitutional. I mean, he lived across the street from the school for...
One countervailing concern there, if you're Mr. Metcalf, and I understand that this is not your most sympathetic person you want to cry, but he does have local police officers that keep coming to him because he gets phone calls, and those police officers just leave and basically don't do anything about it. So if you're Mr. Metcalf and you're not, it would not be too surprising to take away from that what I'm doing does not actually violate law. Now, we all understand there's federal law and there's state law, et cetera, but I could understand where somebody would come to the wrong conclusion there.
May I answer your question, Your Honor? Well, I think the facts show that wasn't the case. He was told repeatedly by law enforcement he couldn't do this. Like, this assertion that he was told he could do this by the state is wrong. He was told repeatedly by the state he couldn't do it under federal law, and they were calling the ATF. And then even when he was told he was in violation...
he called the ATF.
I'm sorry?
I thought he called the ATF, or he called the FBI.
No, well, he called the FBI at the same time as, like, Billings Police was calling the ATF and saying, he's saying he's not going to stop. And then... a Billings task force officer with the ATF, and the ATF came out and talked to him. He was calling the FBI because he thought Billings police were harassing him.
I mean, you're kind of being to Judge Owen's point, a guy who thinks, your point is, it's obviously clear to him that what he was doing was illegal, but a guy who thinks he's breaking federal law doesn't usually call the FBI to say, hey, let me tell you what I'm doing so you can stop these people from... It doesn't look on the entire record.
There's a lot of mental health issues here, as I noted in my response. He had extreme paranoia. He essentially failed out of his mental health counseling.
So you have a guy with extreme paranoia calling the FBI to... Again, it just doesn't fit with the idea that this fellow necessarily knew, which I understand to be your argument, against the rule of lenity, constitutional avoidance, at least the rule of lenity.
Well, in as far as he was behaving irrationally, he also told law enforcement that, he knew he was in a school zone and he just thought this was all unconstitutional.
Yeah. Okay. All right, well, we'll hear from the rebuttal.
Thank you, Your Honor. I want to speak really briefly about the history of the case here. This case went to a trial March 25th of last year. The government had some motions that brought before the court concerning the licensure issue, and Mr. Metcalf's previous interactions with law enforcement. And Mr. Metcalf, as the court discussed with Mr. Godfrey, several times was confronted by Billings police. He's often told you weren't doing anything illegal. It was on the front page of the Billings Gazette the day Mr. Metcalf was arrested, a statement from a lieutenant with the Billings Police Department saying he's not doing anything illegal. We are going to talk to our partners in the federal law enforcement. But those are the messages that Mr. Metcalf was getting.
Who said that?
That was Police Chief Matt Lennick of the Billings Police Department. That was printed the day that Mr. Metcalf was arrested.
Because there was media coverage, because people are concerned. There's a guy with a gun across the school, and they're like, what can we do about it? And the police chief said, well, right now, we don't think there's anything we can do about it, but we're going to contact the feds to see what they can do about it.
Correct. Your Honor, I didn't come out here to tell you it was normal behavior. This was I met Mr. Metcalf in a jail cell. I've known him for 2 years now. This is somebody who was getting harassed by this younger gentleman. That person has been found guilty of a felony violation of protective order, is a felon because of his conduct against Mr. Metcalf. Mr. Metcalf got into a situation where he kept calling the police. They kept coming out. They kept telling him, get a video. He'd try to get a video. Now he's following cars. He's staring at the school. They're telling him, you need to get us evidence if you want us to prosecute this guy. It happened. And I mean, we went into detention hearings, preliminary hearings, and law enforcement came in, and you would have been forgiven if you thought that this gentleman didn't exist. This is somebody who was pushed to a pretty extreme place. And I understand the community concern. I understand why the 911 calls happen, the media coverage, the social media. We live in a time where these things can get blown up. And when we went to court on March 25th, Judge Waters ruled on several motions brought by Mr. Godfrey. He wasn't going to be allowed to talk about his interactions with law enforcement concerning his mental state. He wasn't going to be allowed to talk about the fact that he thought he had a valid license. Those are things that were ruled upon the morning before trial, and that's how we wound up pleading guilty and reserving this issue. So, Your Honor, when you talk about rehab and whether that's been preserved, I do think it looms large over this case. And if the court cannot find that the license protected him under the Gun-Free School Zones Act, I would ask it to consider it in his Second Amendment argument. That is part of the analysis here. This is somebody who, looking at those laws, would have no reason to think that by stepping onto the sidewalk, he was committing a federal criminal offense when he wasn't standing 2 feet in front of it. And I mean, we get into issues with that, Your Honor, about, I mean, gosh, how is the sidewalk owned? Does he own it? Does the city have an easement? How much of that is in his head? I mean, this came out in a DOJ press release, this theory. That was the first time I'd heard this theory, that stepping onto the sidewalk brings you into a school zone. I don't know there's any way Mr. Metcalf could have had that in his head. And Judge Van Dyke, I think when we're talking about the language of that exception, well, first of all, the mental state in this is knew or should have known he was in a school zone. And if we look at the excerpts, I believe it starts at 22, where Judge Waters begins ruling on those, on Mr. Godfrey's motions. When he pleads guilty, she tells him it doesn't matter that you knew it was a school zone, and he agrees with that. So that is in the record as well. But the way that this statute, this exception was worded, Judge Van Dyke, they didn't define verify. That's why Judge Waters, and we gave Judge Waters and Mr. Godfrey a lot to think about in this case.
We're running out of time, but if Judge Owen, so, you got, as I was mentioning to your colleague on the other side, it seems there's three things. There's the time element before that they're relying on, the verify, which, as I understand it, they're reading verify as confirm, which I think is probably maybe the best reading, but you have this whole issue of in the criminal context, do you go with the best reading, or is there some real lenity, constitutional avoidance issue? But then there's the law enforcement authorities. Verify and before, it seemed, before, if you think verify can mean assert, and if you can allow the legislature to assert, then the legislature obviously asserted this before he had the license, in the sense of, so I don't see that very, very challenging. The charter part is if the legislature counts as a law enforcement authority, which is super not intuitive, and then I think law enforcement authorities have to have investigative, this defined as having investigative abilities. And I think the legislature, as you both probably know because you're in Montana, there's currently a fight between the legislature and the Montana Supreme Court about, and the legislature has said that it has investigative authority. And so so why would we interpret the legislature as being a law enforcement authority that has asserted / verified before?
Well, I think, Your Honor, I think the governor signed it.
What's that?
The governor signed it.
Right, but
so the legislature enacted.
So you think
passed
the legislature
that, the governor
is a law enforcement authority? Your position is the legislature counts as a law enforcement authority?
No, Your Honor. I mean, the legislature passed that. The governor signed it into law. I think that would be your verification. I mean, the governor.
No, I think that's one possible reading, and that would happen before. But the legislature and the governor are a law enforcement authority?
It's a tough fact for us.
What's that?
That's a tough fact for us. I mean, I can't stand here and tell you that Montana, I mean, this law is what it is. They saw the Gun-Free School Zone Act. Montana didn't want it. They passed this law. I'm not going to stand here and tell you that it checks every box on that, on the exemption. It doesn't. I mean, we gotta get into wordplay to try to get there. But I mean, the way that this statute is worded made Judge Waters have to go back to the dictionary for verification and all these things. And we still don't know what qualified under law means. That's the standard that they have to verify. And what Montana did was looked at this and said, well, qualified under law, anybody who's not qualified under law, anybody who's had that right taken, can't get that license, and we want to give that license to everybody. That's what happened here, Your Honor. I'm not going to try to paint that as something other than what it is. But I do believe that it plays significantly into the broader picture of whether Mr. Metcalf ever could have known he was breaking a law. Thank you.
All right, thank you, counsel. Thanks to both of you for your briefing and argument in this complicated and interesting case. This matter is submitted.